Straight ahead on Law and Crime Daily.
I said, oh, damn, I've been shot, but I'm not conscious.
A Texas man survives a shooting, then learns the suspect is being called a serial killer. His story of survival.
Plus, an Ohio man gets a plea deal for murder, then turns around and implicates his ex-wife. But is he telling the truth?
He's going to pay for by spending the rest of his life in prison.
And a state Supreme Court is reviewing Bill Cosby's conviction, how his victims feel about his possible release.
He has consistently said he feels no remorse.
Later, a potential bribery for a presidential pardon scheme revealed. Our investigative coverage.
Law and Crime Daily covering court cases from coast to coast. Welcome everyone to Law and Crime Daily. I'm Brian Buckmire along with Terri Austin. A Texas man was shot by a supposed serial killer and lived to tell the story. Law and Crime Daily's Angenette Levy spoke with the victim and had his incredible tale.
You know, Brian, it is nothing short of a miracle that Marshall Boyd survived this shooting. His girlfriend was actually sitting right next to him in the car when the shooting happened, and she escaped without a scratch.
When I got shot, it was like I was floating in the deepest, darkest water.
Marshall Boyd is home from the hospital after surviving a hail of bullets fired at his car.
When this gentleman pulled back up next to us, he had his window down, and that's when he started firing. And the first, I don't know, first shot hit me in the head, and so I don't know, I can't tell you much after that.
The bullets hit Boyd in the back, head and hand. Stephanie Thomas ducked and fortunately wasn't hit.
He kept telling me, call my kids, tell them I love them, and I love you, and call my mom. And I'm like, you're going to tell your kids you love them. Don't talk like that. Just stay with me. Stay with me.
Boyd and Thomas shared these photos of the car. Dallas police say 31-year-old Jeremy Harris fired 16 times. He's also charged with killing the father of his ex-girlfriend and 3 people in Dallas that he didn't know. Police say 2 other people survived being shot.
In my opinion, based on what I've seen so far, I believe that this is the definition of a serial killer. It's random. There is no known association between victims.
Police had released surveillance video and a screenshot of a black Chevy Tahoe used in the shootings. Boyd says Harris was driving a black SUV when he was shot. He's grateful to be alive.
When I found out that nobody had survived an encounter with this guy yet, I was even more emotional about it all. It's been an emotional thing.
And Dallas police actually said that Jeremy Harris has a minor criminal history, things like theft and drug charges, even domestic violence, but nothing like murder or robbery. Marshall Boyd's sister has set up a fundraising page on Facebook to help with his medical bills and the cost of replacing things on that vehicle. Brian.
Wow. And Angenette, has he said if he plans to testify if Harris goes to trial?
Yeah, actually, they've been told, both Stephanie Thomas and Marshall Boyd, they've been told that they will be subpoenaed and will likely testify. They're really some of the only living witnesses to these crimes. And Marshall Boyd says he is eager to testify.
I'm going to testify on his too. I'll be right there in that courtroom. Promise you that. I'm not scared of him one bit. What he needs to be scared of is the rest of his life in prison.
Jeremy Harris remains in jail right now. He's being held on a $3 million bond. Brian?
Remarkable story. Thanks very much, Angenette. And for legal analysis on the case, Terri Austin joins me. Terri, police have labeled the suspect a serial killer, but some of our viewers say it was more like he was on a killing spree. What are your take?
You know, I think it's really a distinction without a difference, whether you call it a spree or a serial killing. I think the fact is there were multiple deaths here at different locations. And, you know, what they define as a serial killer is someone who is actually having a plan, someone who's thinking about it, taking their time between each killing. So, you know, I think it could be called a serial killer. If it's really, really random, then maybe you could call it a spree. But I think the bottom line is, you know, there were multiple killings here.
Yeah, it's interesting. A lot of the FBI literature and other jurisdictions I've looked at doesn't really describe what a serial killer is. It's just 3 or more killings with pauses in between. and it differentiates that from a mass murderer. Thank you very much for that, Terri. Now, Terri, you've got an update on a case that we've been following closely.
I do. I've just learned that a hearing for one of the suspects of the so-called doomsday cult couple will have a hearing on a request for a change of venue. Lori Vallow and her husband, Chad Daybell, are accused of covering up the deaths of Vallow's two children, J.J. Vallow and Tylee Ryan. Neither are charged with murder, but the children's bodies were discovered on Daybell, Idaho property. A judge ruled the couple must go to trial together, but Daybell's attorney is requesting it be moved to a different district. Daybell's attorneys say it will be impossible to find an impartial jury in Fremont or its surrounding counties.
All right, that's kind of an interesting argument, but Terri, that's not all Daybell's defense is requesting, right?
That's right. They are requesting this change of venue, as we mentioned, and they're also requesting a motion to dismiss citing insufficient evidence, which is incredible when you think about it, because the charge is the destruction of evidence, and the bodies were actually found in his property. So I think that motion is clearly not going to prevail.
Yeah. And of course, we know as both of us being lawyers, you've got to file the motions, you got to put them through. But as you look at some of these motions, do you think that any of them have a chance of being successful?
Well, you know, it's very interesting. I do think there's a slight possibility that the change of venue motion could succeed. But, you know, whether it's in Fremont or whether it's in Madison County, everyone in Idaho, and in fact, everyone in the world knows about this case. So I think changing the venue is not going to make a difference, and I think that the defense will lose probably both motions.
Yeah, we'll see how that plays out, and of course, we'll give you guys the updates as that plays out. Still ahead on Law and Crime Daily, should Bill Cosby's conviction be overturned? We break down the appellate arguments. But first, the attorney for a man who pled guilty to murder tries to explain why his client is pointing the finger at someone else. That's after the break. Welcome back. An Ohio woman is facing life in prison for the murder of her ex-husband's former girlfriend. A jury convicted Erica Stefanko of murdering Army veteran Ashley Biggs. Her ex Chad Cobb testified that Stefanko placed a fake pizza order to lure Biggs, a delivery driver, to her death. Cobb pled guilty in a deal that took the death penalty off the table. After Stefanko divorced him and married him for his friend/boss, he implicated her in the murder. The Law and Crime Network spoke to Cobb's former attorney and asked him if he could explain why Cobb denied strangling Biggs with a zip tie during Stefanko's trial.
Well, no, is the short answer. You know, the physical evidence was pretty overwhelming. I was surprised by that testimony. I really don't want to speculate on Chad's motives. I can tell you, based on what I had seen at the trial, that it was clear that there was some difficulties between Chad and his ex-wife. I don't think it's any secret, and it came out that Erica ended up marrying Chad's best friend. I don't think it's any secret. It came out during the trial that there was some custody issues between Cindy Cobb, Chad's mom, and his parents, and her ability to see and have access to her grandkids. I think that certainly didn't help Erica's motive to not get detected, and I think that had some play in Chad ultimately coming forward and agreeing to testify.
But inconsistencies did pop up in Cobb's testimony under oath, so we went back to Cobb's former attorney and asked him if we should believe Cobb's latest story.
I mean, I believe, based on my view of the evidence, that Chad Cobb was telling the truth. There were certainly some discrepancies. How major, how minor those discrepancies were, I guess, is up to the jury to decide. I think they felt that Chad was telling the truth, and obviously felt that his testimony was credible enough to convict Erica of these very serious offenses.
Now remember, a key piece of evidence was a secret recording Cobb's mother made of Erica Stefanko confessing to her involvement. So why did Cindy Cobb hold on to the recording for 4 years?
What I found Cindy Cobb to be was a very loving mother who was deeply concerned about her son. As you can tell during her testimony, she wasn't making excuses for him. She knew he had to be held accountable for his role in this. And I also found Cindy Cobb to be a very involved and very concerned grandmother. She would do anything for those kids. And the idea that Erica was going to try to keep them away from her is a huge motivating factor, in my belief, causing Cindy to take some action and do what she could to be with her grandkids.
Terri, what do you make about a defense attorney speaking about their client like this? Keep in mind, this is the same attorney who arranged a plea deal for Chad Cobb to spare him from the death penalty in this case.
Well, you know, I think he cannot ignore the fact that Chad's testimony was very inconsistent, not just a little bit inconsistent. He's talking about details, but they were huge issues. I mean, one, that he pled to actually killing Biggs, and now he's saying he had nothing to do with it and that Erica Stefanko had everything to do with it. So I don't think he can actually say that these were minor inconsistencies.
Agreed. Now, Cindy Cobb's explanation for holding on to the recordings, or even making them for that matter, does that make sense in your books?
Yeah, well, you know, here's what I think. She made those recordings and she was saving them for a rainy day. And the rainy day was the fact that she could not see her grandchildren the way she wanted to. And so she decided to use this recording at a time when she could use it against Stephanie or Erica Stefanko. So, yeah, I think that it was very calculated on Cindy Cobb's part. And I think as a mother, she clearly was doing everything she could to help her son as far as, you know, implicating somebody else is concerned.
Yeah. And I get it. Some people might perceive that to be a little shady, a little underhanded, especially in terms of the timing. But at the end of the day, Erica Stefanko spoke on a recorded tape, even though she didn't know it, and the jury heard it and considered it. Terri, thanks a lot for the update on that case. Coming up on Law and Crime Daily, possible bribes for presidential pardons. Our report investigates. Plus, will convicted comedian Bill Cosby be successful in his legal bid to overturn his guilty verdict? Our legal analysis after the break. It's up to the Pennsylvania State Supreme Court. They'll decide if disgraced comedian Bill Cosby's conviction should be overturned. Cosby was convicted at his second trial in 2018 of sexually assaulting Andrea Constand in 2004. His attorneys are arguing that 5 women should not have been allowed to testify about uncharged bad acts, basically claims that Cosby assaulted them too. Attorney Gloria Allred represents 33 accusers. 3 of them testified at trial, and she says their testimony should stand.
By showing the testimony, allowing the testimony of prior bad act witnesses, it shows that Mr. Cosby was not mistaken about whether Andrea consented. Because look at the testimony of the prior bad act witnesses. If he is drugging and sexually assaulting other women, he knows that if a woman is incapacitated by alcohol or drugs, she can't consent. He's not mistaken about it. He's doing it so that they can't reject him. In other words, not consent or consent. They're incapacitated. And that is why they wanted to show it. That, and of course, because they want to prove a common plan, scheme, or design that Mr. Cosby had.
Now, Terri, the judges were really pressing the prosecutors about why they needed these additional witnesses. Some agreed there was prejudice. What do you think of the judges asking why the prosecutors needed these additional witnesses?
You know, I listened to the judges' questions, and the fact is sometimes judges ask all of these questions, and it seems as though they are leaning in one direction when in fact they're leaning in the other direction. So I don't know at the end of the day what the result will be, but I think as far as these other witnesses, the prior bad act witnesses are concerned, that it makes sense to allow some of those witnesses, maybe not 33, maybe not 1, but maybe 5. So I think at the end of the day, we may see that that particular issue is going to stand and that there won't be any reversal as far as that issue is concerned.
Agreed. Now, Terri, one of the strongest arguments the attorney Bojan had was that proof of prejudice was obvious because there was no conviction when only one bad act witness testified in the first trial. What did you make of that argument?
You know, actually, Brian, it's an excellent argument because, you know, when there's only one witness and there's no conviction, and then ultimately you see when there are five, it is sort of at the end of the day, the results showing that there might have been some prejudice as far as that was concerned. So I think it was a good argument, but whether or not that argument prevails, I think we'll see.
Yeah. Now, Terri, my struggle with this is that Cosby's attorneys may be right, but only because I think the law has never really contemplated one person having so many bad act witnesses. I mean, 33? Should the system change to accommodate these unique circumstances, or what are your thoughts?
You know, what's sad here, Brian, is that we have cases like Epstein, Weinstein, here Cosby, where there are so many bad acts, prior bad acts, and maybe the law does need to be changed so that we can see some more of that evidence as far as these defendants are concerned. If in fact it has to do not with their propensity to commit a specific act, but obviously it has to do with their scheme and their opportunity and their plan. So maybe the law should be changed, but absolutely we have too many of these to think about.
Yeah. Now, of course, if this case does get overturned, the prosecution can come forward with the same charges and retry the case again like they did the first time. Thank you, Terri. Now, when we come back, a federal judge unseals an explosive report where senior White House officials part of a bribery for pardon scheme. What documents reveal next. Are people paying for presidential pardons? Well, recently, unsealed federal documents claim unregistered lobbyists tried to do just that. Law&Crime senior investigative reporter Adam Klasfeld is here with a bombshell report. Adam.
Hi. Well, as you said, this was a bombshell court order that was unsealed yesterday from an investigation that we know has been ongoing since at least August. The order basically showed that federal prosecutors had been looking into what they called a bribery for pardon scheme and also a secret lobbying scheme. Now, the secret lobbying scheme tried to ply senior White House officials, according to the court papers, and that essentially the government has been trying to get information about this, and they went to court to try to defeat attorney-client privilege. The judge allowed it. And that investigation, when she allowed it, Chief District Judge Beryl Howell basically gave a 90-day window and said, at the end of these 90 days, you have to tell me what we can release publicly. And so we're finding out about it now.
All right, so you said a few things that kind of caught my ear. You said it happened since August, but why are we finding out about just now? And do we know who unsealed these documents?
Well, the judge basically gave that 90-day window, and she told the government, at the end of these 90 days, let me know what I can release publicly. Now, interestingly, the Department of Justice tried not to release anything, and they recommended to keep it entirely under wraps. Judge Howell rejected that. And so essentially, by overruling them, she gave us a little bit of a public window of an investigation that has been long brewing.
Now, for most attorneys listening to this, when you hear they broke attorney-client privilege, like if my client kills someone as a public defender and they die, even after they're dead, I'm not legally allowed to break attorney-client privilege. That's pretty strong. Are there any indications that something really, really bad happened to break that attorney-client privilege in this situation?
There were a couple of grounds in which the judge allowed this evidence hunt to go forward. One was the crime fraud exception, and another was simply that the person who was entrusted with the documents that the government was trying to get was not, in fact, an attorney. So that's part of the reason why the government got the green light on this. And we are likely to get more transparency because the judge basically kept a schedule and saying that in the future, let's bring more sunlight to it. So people are looking into the details that were released, and those details are explosive, and we are likely to learn more as this goes ahead.
All right, so quickly, it's a two-part scheme. Can you just tell us what the two parts are in this scheme they're saying happened?
Absolutely. Well, they are divided into a secret lobbying scheme and a bribery for pardon scheme. Those are direct quotes. And interestingly enough, what the court said is that these were related schemes. So the scheme for lobbyists, without any disclosure, to be trying to ply senior White House officials is related to the bribery for pardon scheme that involves a tacit promise of a substantial political donation, that there was a history of substantial political donations, and they wanted clemency for their client.
All right. I like it. The best part about that one is no attorney-client privilege because some of them wasn't actually an attorney.
Exactly.
That's a good one. Adam, thanks so much for the report. We'll see you next time.
Thank you very much for having me, Brian.
Yeah. Now, Terri, these presidential pardons only apply to federal charges. So even if the president grants them, that means these individuals could still face state and local charges, right?
Yeah, no question about it. Actually, there are more federal charges too, but we won't even get into that. But as far as the state charges are concerned, there are charges as far as the family business is concerned, charges for insurance fraud. There's in New York, criminal tax evasion. We've been trying to get his tax returns, federal bank fraud charges. So there are lots of charges against him on a statewide basis, particularly in New York.
All right, thanks, Terri. And thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.